Further hearing in the appeal, Commissioners for Her Majesty's Revenue and Customs against NHS Lothian Health Board.
Yes, Mr. Sovereign.
My Lord, with the indulgence of the court, we'd like to ask for an extra 12 minutes, and we will complete our submissions by 12 o'clock.
Well, shall we see how we're going along?
Yes, indeed. We'll try and finish them by 11:48 was the time your Lordship indicated. Yeah.
We certainly felt yesterday that we could have been making more rapid progress than we were.
Of course, my Lord.
If we speed up a bit this morning, it may be that you can finish within the or previously allotted time. We'll see.
Then I will not delay the court further, my Lord. There were 2 points from yesterday's hearing. My Lord, Lord Briggs recalled the example of young barristers who registered for VAT and then obtained a repayment of VAT because their input tax exceeded their output tax. That was, of course, correct. The point is that they were recovering their VAT in the prescribed accounting period in which it was incurred, and that is, of course, the normal, regular procedure for VAT. Now, where that doesn't happen, my Lord, Lord Legate raised the question of on what basis can it be said that the right to obtain repayment of input VAT in periods subsequent to the period in which it should have been deducted was a directly effective EU law right. Well, I think the answer to that question is that the Court of Justice, in interpreting the directives, makes no distinction between overpaid output tax and under-recovered input tax. They're alike regarded as sums of money held by the state to which it is not entitled. And I think it's sufficient to refer to paragraph 28 of Lord Walker's judgment in the Fleming case, which is at 1655. And what Lord Walker says there, it is common ground that Article 18 gives taxpayers directly enforceable community rights. The UK has opted under Article 18.4 to permit refunds, and it has carried out its task under Article 18.3 of laying down the conditions and procedures for obtaining credit for input tax, which is not dealt with by the normal regular procedure in paras 18.1 and paragraph 18.2 of Article 18. That is, by having a proper tax invoice as a voucher and by deducting the input tax from output tax payable in respect of the same quarterly accounting period. And I should have said he quotes Article 18, and that is now Articles 179, 180, and 181 of the Principal VAT Directive, which is at pages 1539 and 1540. The position under the directives is as follows. 1, the taxable person has the right to deduct input VAT in the prescribed accounting period into which it was incurred, Article 178. If he fails to do so, the right of repayment does not cease to be exercisable. It remains available to be claimed in the future without limit of time. So, University of Sussex. So 3...
Sorry, I thought you said that you were describing the position under the directives.
Yes, that is the position as summarised in the University of Sussex.
I'm sorry, it's not clear to me at the moment that what you've told us answers Lord Legate's question. We can see the right I mean, undoubtedly there's a right of deduction conferred by the directive, which is directly effective. But when you look at the directive, it's conditional under 18.1 on the possession of an invoice.
But then, as Lord Walker explains, member states may opt to allow late recovery under conditions and procedures laid down under Article 18.3 and 18.4
yes,
of the Sixth Directive.
Well,
but I mean, in what sense is that a directly effective right? I mean, if member states have the option whether to allow that or not.
Because once the state makes use of that option, that becomes subject to the principles of effectiveness and proportionality, and the authority for that is Teleos, para 45 of the judgment. And of course, Fleming was all about accrued rights, the fact that when on the 1st of May 1997, taxpayers had accrued rights to recover input tax, which hadn't been recovered at the time when it could have been or should have been recovered under the ordinary procedure. And of course, member states may introduce time limits to prevent the exercise of the right, but it was in this area that the UK legislation infringed the principles of effectiveness and respect for legitimate rights, and Marks and Spencer's held that that was incompatible with EU law. And we looked at this yesterday, and it's paragraphs 36 to 38 of the judgment in Marks and Spencer's, which is at 2579 to 2580. And the remaining citadel waiting to be stormed was the 3-year limitation period contained in Regulation 29.1a, and in the Fleming litigation, the House of Lords held that Regulation 29.1a had to be disapplied. And the reason was reasonable transition arrangements could only take place prospectively. They could not be introduced ex post facto because the taxpayer had no means of knowing when the transitional period would have commenced or how long it would have lasted.
At the moment, it seems to me that if a right is derived from domestic legislation, which EU law gives the member state a discretion to enact or not enact as it pleases, then the right can't be described as a directly effective right under EU law.
That was what the House of Lords considered in Fleming, and I quoted from paragraph 28 of Lord Walker's judgment, which we would regard as answering that point.
I mean, he's recording, well, first of all, he's recording a matter that was agreed between the parties, it's common ground, and the agreement was that Article 18 gives taxpayers directly enforceable community rights. Well, I don't doubt that. I'm sure it does. But not necessarily if the right is one of the kind that I've just described. It's a right the existence and scope of which is determined by the member state under its own domestic law.
Yes. I mean, the answer to that is that there was never a reference to the European Court. The Commission has proposed making a reference to the European Court. The House of Lords declined to do so.
Yes.
So we don't have, in relation to late recovered input tax, the equivalent of the Marks and Spencer's decision in the European Court.
Mm.
I mean, I would have thought that ordinarily when one talks about EU directives being directly effective, you're talking about the rights set out in the directive itself. Mm-hmm. You seem to be talking, if I may say so, about a different principle, which is EU principles of equivalence and effectiveness in relation to domestic procedural choices.
Yes.
Which is not as such a matter of direct effect of something in a directive. It's a result of different principles of EU law, isn't it?
Yes. Principle of effectiveness, proportionality, respect for legitimate expectation, legal certainty. These all form part of the general principles of EU law. The acquis communautaire, which the UK was obliged to comply with under Section 2.1 of the European Communities Act 1972, the acquis communautaire embraces both the general principles of EU law and the legislation passed by the Union.
But there was only one breach of EU law relevant ever identified here, and that breach was introducing a retrospective time limit for input tax claims without giving a reasonable opportunity to make such claims before it came into effect.
But as my Lord pointed out yesterday, that presupposed that this was a directly enforceable EU law right. Otherwise, there'd be no point to it.
No. The only EU right was not to have a limitation period introduced without any opportunity to make claims that were previously allowed. That was the only relevant EU law right.
We would argue that that presupposed the existence of the EU law right, otherwise it wouldn't have called into play the principles of effectiveness, non-retrospectivity, legal certainty, and proportionality.
Well, there's no authority anywhere that says that, is there?
I think
I read the whole of Fleming last night, and it seemed to make it clear that the only breach of EU law was the one I've just mentioned. It would have been perfectly acceptable under EU law to have a time limit of 3 years.
Indeed.
It would have been perfectly acceptable under EU law to introduce a 3-year time limit retrospectively. The only thing that wasn't acceptable was to do that so that it came into effect tomorrow rather than giving people 6 months or 12 months leeway in which to make a claim if they had one before the new time limit was brought in.
Yes.
Yes, but we say there is a prior question, rather like with human rights. The first question is, does the action in question come within the scope of human rights law? Is human rights law engaged? And equally, we have the prior question here, is the right within the scope of EU law? Is EU law engaged, or is it purely a matter of national law?
Yeah, that strikes me as being a different question from the question of direct effect. And I take your point that one way of putting it would be to say that if a member state is exercising a power conferred by EU law, then it has to do so in compliance with general principles of EU law, including the principle of legal certainty.
I think probably the authority on this, and I can't remember the name of the case, was the 1970s case on the insurance exemption. And the name Berger comes to me.
Yes, Barber and Guardian Roll Exchange.
Yes. But there was a second one on, which I should be able to remember, but can't at this moment. And that involved a German lady who wanted to claim the exemption as an insurance broker or agent. Germany hadn't at that stage implemented that part of the 6th directive, but the European Court held that she could rely on that part of the 6th directive regardless of whether or not it had already been implemented in the member state, because this was a free-standing EU law right.
But clearly that wouldn't be true in the present case, because you couldn't rely directly on the directive for making a late claim.
Well, you could rely directly on the directive, because the directive gave you, in Article 18, Paragraph 1, now, Article 178, the right to deduct input tax. If you didn't make that use of that right...
I'm so sorry, I thought that was only if you had the invoice.
Yeah, that's what it says.
That was the next stage.
You say the next stage, it's written into Article 178 itself, isn't it?
Yes, but then we have the subsequent provisions, which if we go to the legislation in force at the time, which would have been Article 18 of the 6th directive, we have the two sections which...
And I'm so sorry, where do we have that in the bundle?
I don't think we've got Article 18, so I'll do it from Article 179 and 180.
But it's simply impossible to spell out an indefinite right to make claims forever, because the M&S case, which you showed us yesterday, says that you can have a time limit to 3 years if you want.
Yes, of course.
And you can introduce it retrospectively.
With suitable transition arrangements.
And the only point you make, you cited to us the Telios case twice, para 45, which I've looked at, page 2690, and that says exactly what Lord Reid has said just now, which is that if member states exercise powers, they must comply with general principles of law, which include, in particular, the principles of legal certainty and proportionality. It doesn't say that you have a directly effective right under EU law to make claims forever.
But what it does imply is that if the member state can limit, can restrict the exercise of that power, of that right, it does presuppose that if the member state fails to make use of that facility, the right continues to exist. Otherwise, there's nothing you need to limit the exercise of.
Well, that's why you've got another 10 years here, and you had the chance to put in the claim that you had before 2008.
That is another story. That is another story. Why the right wasn't exercised earlier. Why didn't the University of Sussex exercise its rights earlier? Answer, it's irrelevant to the question whether they have sufficiently established the existence of the accrued right to recover. There wasn't any argument here that there was an entitlement to subject to the points which my learned friend makes in the Commissioner's written case. There was no argument here that there was an entitlement in the broad sense. The issue was, sole issue was, whether it had been adequately quantified.
Well, the entire fallacy of your case seems to be that you're arguing that because the claim wasn't time barred when it was put in, so that it was still open to you to make a claim 30 years after the event, because you'd waited for 30 years, that somehow gave you a dispensation from the ordinary principles of proof and evidence, which wouldn't have existed if the claim had been made timelessly.
That is correct, but that is because the UK chose to make use of this option to allow alternative evidence, and that is really set out in the rider at the end to Regulation 29(2). My learned friend took you to Regulation 29 yesterday, but didn't refer to the rider at the end of Regulation 29(2).
Now, one of the problems with the legislation we have is we don't have a version that was in force at the time.
Well, I do beg your pardon, my lord.
Take us to that, because it refers back to the Regulation 13, and that includes the let-out clause that if you don't have the invoice, the commissioners can direct either generally or in a particular case that they will accept other evidence.
That is indeed the case, my lady.
The question is whether HMRC were entitled to say that even that standard had not been met in this case. There had not been sufficient other evidence to convince them.
Yes, my lady. The rider which was relied on, or is relied on, in the late recovery cases are the words at the end of Regulation 29, subparagraph 2, provided that where the commissioners so direct, either generally or in relation to particular cases or classes of cases, a claimant shall hold or provide such other evidence of the charge to VAT as the commissioners may direct.
Right. But that applies whenever the claim's made, so you're not relying on any difference because it was made 30 years later.
No, we're not.
You're just
precisely.
saying that the ordinary rules applied in this case.
Yes.
There was no error of law in treating those rules as applicable. The error was that no reasonable tribunal could have reached the conclusion they did on the normal rules of evidence?
Well, the question is, what is the test for when whether HMRC should have accepted the alternative evidence? And that was an issue in the Scandico case, which I decided in the upper tribunal, which is in the bundle, which is, again, whether it's even for the first tier tribunal to substitute its own assessment of the adequacy of the evidence, or whether it's simply reviewing HMRC's decision not to say that the evidence is adequate or to say the evidence is inadequate.
Well, that is precisely the point which your ladyship has made. And again, I'm afraid your ladyship will know the case. I've forgotten the name of it. And that was where, in effect, the upper tribunal said there are two stages. Not, and this was what the tribunal said was wrong, you don't ask first liability, second quantity, those are one and the same question because they're usually interrelated to each other. But the decision of the commissioners whether to accept alternative evidence is purely a review matter. Have they acted reasonably? But once the commissioners accept that alternative evidence for consideration, then it simply becomes a full appeal. And we think that is consistent with what the Court of Appeal said in John D.
I'm not sure it matters very much in this case because it's quite clear
it doesn't in this case because we've been arguing for 12 years about... I do beg your pardon, my lord.
Sorry, I was just making the point that we're dealing with a case where whatever was the relevant approach, the tribunal looked at the matter itself and the whole proceedings have proceeded on the basis that that was appropriate for them to do, and the question is whether they did it rightly or wrongly. But I'm so sorry to pursue Lord Legate's point. I'm struggling to follow what point you're making on the proviso at the end of Regulation 21.2.
Well, the proviso at the end of Regulation 29.2 is precisely providing for the consideration of alternative evidence where, for example, the requirements of Regulation 13 are not satisfied, which will normally be the case with these late claims.
Right, but how does that help your argument before us? I mean, I can see that that's, if you like, the doorway through which you have gone, which takes us into this world where, although you don't have invoices, you still say, well, we've got other evidence, please, tribunal, look at the other evidence. And the tribunal did look at the other evidence and said it wasn't good enough. So how does this help you to show that the tribunal went wrong?
I think this helps us, this is a consequence. It doesn't help us to show that the tribunal went wrong, certainly.
Okay.
But we say this is one of the consequences of the right to recover unrecovered input tax being a directly effective EU law right, because the UK opted under what was Articles 18.3 and 4 of the 6th Directive to allow evidence to be produced outside the normal claim period.
So is this right, that you rely on the rider to say that when HMRC are exercising their discretion whether to accept evidence other than VAT invoices, properly so called, they must exercise that discretion, bearing in mind the principle of effectiveness as it applies to these kind of late claims, and that principle should influence them, and hence, if it doesn't, it should influence the FTT to say, no, you should have accepted this alternative evidence in order to give effect to this ability to make a late claim for unrecovered input tax.
That is exactly our argument, my lady.
The difficulty with it is that effectiveness isn't a general principle of EU law. It's a principle that applies to directly effective EU rights, which is where we began.
Which is where we began, yes, indeed. There's danger of going round in circles. But I think one can say that if the law were otherwise than as we suggest, all the parties in the Fleming litigation, the commissioners, the taxpayers, 4 layers of courts, would have been proceeding under a fairly fundamental misunderstanding, and all the legislation which Parliament enacted under Section 121 and the consequences of that would turn out to have been an unfortunate, unnecessary and an unfortunate misunderstanding.
I'm so sorry. I just don't follow that point. So I can see that where a member state passes legislation within the scope of EU law, the phrase changes, but not directly to implement a directive, but it's within the scope of what the subject matter of the directive is. General principles of EU law come into play, as my Lord Reid said, and parties can rely upon those, even if there is no directly effective right in a directive which they're able to rely upon. Those general principles include things like legal certainty and legitimate expectations, not the principle of effectiveness, again, as my Lord points out. I would have thought that in the Fleming case, what you had was a situation where the state has legislated within the scope of the directive, but not in respect of any directly effective right as such, but that was sufficient to bring into play these general principles, including legal certainty and legitimate expectation. And it was that gave the claimants their rights in the Fleming case and enabled them to say that those rights of EU law, not directly effective under a directive, but arising from general principles, were being defeated by the introduction of a sudden new limitation period without the transitional period, because it was defeating their interest in legal certainty and legitimate expectations. Have I misunderstood?
No, that, with respect, my lord, is what I have been trying to say less clearly.
All right, but that doesn't get you home, get you into the territory of the principle of effectiveness, which is what I thought you was trying to found your argument upon.
We are trying to found our argument on that because what we say, and in fact, this is exactly what the House of Lords said in Fleming, where they said the this is paragraph 11 of the House of Lords decision, this was necessary.
So sorry, disapplication. Could we have the page reference just so we can follow what you're saying?
Yes, the page reference.
656, I think.
Sorry, it's 1648.
Very grateful, thank you.
1649 is paragraph 11, if that's what you...
Right.
So it's paragraph 11,
That's where, and this in fact is Lord Hope, this was necessary to give effect to the principle of effectiveness. I mean,
does anyone else, just out of interest, does anyone else agree with that way of putting it?
I don't think it's how Lord Walker and Lord Newberger put it.
Well, I think on that, all 5 law lords were of the same opinion. The dissenting part was where Lord Walker suggested that this gap in the UK legislation could be filled by administrative action rather than by legislation.
I'm just looking at paragraph 11. The introductory bit seems to me all to be put in terms of what I would have thought of as general principles of certainty and legitimate expectation in EU law.
You may get some help from paragraph 16, Lord Scott, who looks at it through the prism of Marx and Spencer, and therefore being about the principle of effectiveness and the protection of legitimate expectations.
Yes, legitimate expectations are also referred to by Lord Hope at paragraph 9.
Yes, I mean, there is the conundrum which this answers, which is, well, if you don't have an entitlement to make a late claim at all, how can it be in breach of the principle of effectiveness to unfairly stop you from making a late claim that you were given by the government? But that often happens, that the fact that the government wasn't required to do something doesn't always mean that if they choose to do it, there are no controls on the fairness with which they do it. So there isn't necessarily a conflict there, but I think we're still exploring to what the principle of effectiveness actually attaches.
Also, I see that Lord Hope's discussion is of overpayment of output tax and the operation of Section 80, as well as omissions to deduct input tax and Regulation 29, and he doesn't seem to draw any distinction between the two.
There's a citation from the paragraph 22, there's a citation from the Grundig case based on the principle of effectiveness.
I mean, that was the point I was trying to make earlier. I think what's important also is where Lord Hope says in paragraph 10, there is a gap in the legislation which is unfilled. The infringement of EU law in this respect cannot be said to have been comparatively minor or inadvertent, such as would enable greater weight to be attached to the state's need for legal certainty in matters of taxation. The primary responsibility for giving a clear indicator to taxpayers as to where they stood with regard to the making of claims, despite the retrospective introduction of the time limit, lay with the legislature and the executive. So the House of Lords, was there recognising that their judgment did leave a clear gap in the legislation. You had EU law rights which, as they provided the framework, they need to be given a specific form in UK legislation which made clear what the position of the taxpayers was, and the solution of Parliament was Finance Act 2008, Section 121.
I mean, I can see that Lord Hope and others refer to the principle of effectiveness as well as the principle of legitimate expectation. But, I mean, to my way of thinking, paragraph 10 actually is focusing on legitimate expectation. Because what he seems to be saying is the state has an option as to how to proceed. There's a gap which the state, a gap in effect EU law, in the legislation, which is unfilled, so that the state can choose how to fill it, not mandated by EU law to do so in any particular way. The question then is weighing up the state's interests. Does it have to act absolutely immediately without notice, or is it a case where the principle of legitimate expectation means that notice should be given? Answer, it's the latter, that notice should have been given and it wasn't, and that was the breach of EU law that was found.
When you look at, I'm just looking at the moment at paragraph 5 of his judgment at the foot of page. I'm afraid I can't read it on my laptop. It begins 164, but I don't know what comes.
1647.
He says, just reading from the last line, it's plain that the unmodified time limit in Regulation 29(1)A is incompatible with EU law because it is retrospective and because it makes no provision for any transitional arrangements. This much was common ground in these appeals, so it's not even an issue in the case. The question which your lordships must resolve is how to apply guidance in Marks and Spencer in order to make good the lack of a transitional period. There's a possible choices set out by Lord Walker. Underlying these possible choices is a more fundamental point, where national legislation is defective because it lacks the transitional arrangements that are necessary under EU law, is it for the national court to make good the deficiency by devising such transitional arrangements as it may regard as appropriate, or must this be left to the legislature? Well, the point that we're debating doesn't appear to have been an issue in the appeal at all.
No, because it was common ground at the time.
Yeah.
I think probably if we... My learned friend, Mr. Edwards, will be able to help the court further with this. Let me just very briefly sum up, having regard to timing and the fact that we're due to finish at 11:48. Section 121, we say, has to be interpreted in the light of Parliament's intention, which was to clear up all these matters once and for all. We say that the intention of the legislation was accurately reflected in the Fleming guidance published by the Commissioners on the 17th of March 2010, which is at page 1468, and we would draw attention in particular to paragraph 2.2 at 1477, paragraph 2.4 at 1479, and paragraph 2.6 at 1481. My Lord Reid observed traditionally the state doesn't litigate against the state. We would agree, and in the board's view, these sort of disagreements should be resolved by discussion, negotiation, interdepartmental dealings. But we've been searching for a reasonable accommodation for 12 years and got absolutely nowhere.
Yes. I wasn't suggesting that there was any blame to be attached. It was simply an observation that there's been a change in the culture of public institutions.
Well, there has indeed been a change in the culture, and I said yesterday this was a question for future political historians and scientists to reflect on. I think to some extent it's the move to more formal constitutional arrangements, but this takes us a long way from the matter in hand. Fundamental argument of the board is set out at paragraph 52 of the Court of Session, which is at 3018, and there the court says, or the Inner House says, fundamental argument for the taxpayer is in the light of the findings that the activities carried out in the taxpayer's laboratories did not change during the period of the claim to any material extent, and that the nature of the inputs would not have changed markedly throughout that period, the 14.7% agreed for 2006 to 7 should be extrapolated backwards to earlier years. And that has always been our case. The court.
Well, there's a gap in that case, as was pointed out, because the fact it didn't change between 1974 and 1997, there's no finding it didn't change between 1997 and 2008 or whenever it was.
No, that...
You can't get to the starting point.
With respect, my lord, no, the witness evidence did cover those what had happened after 1997, because there are a whole series of questions on that.
But there may have been witness evidence, there were no findings. In fact, the findings were the other way, because the tribunal gave reasons why it was not prepared to accept that the position was the same in the earlier period as it was in 2006, 2007.
In that case, we would say that was inconsistent with their finding of fact, which the commissioners have never disputed, at 189. And if we look at the witnesses, Linda Mulhern had started working in 1988 and was still working there. Gillian Fenster was working there from 1973 to 2000. Jane McIvor had been there from 1980 and was still working for them. And Dave Wright was there from 1981 to 2014. So in terms of putting together, as it were, witnesses who had knowledge of what was going on both in the claim period and thereafter, really the board could have done no more. But I think, let me hand over to Mr. Edwards, who will deal more thoroughly with effectiveness and state fault.
Thank you very much, Mr. Southern. Yes, we'll give you a moment or two to rearrange things.
My Lords, I'm grateful. I will be, my lady, I'll be as quick as I can be.
Well, there shouldn't be any, I hope there won't be any rush.
But it's always better to impose a time limit on me, my Lord.
We do, of course, have your written case also.
Exactly. And I'm going to begin, if I may just turn directly to my submissions rather than setting out what I'm going to say, but essentially I'm going to address the court on what we say the principle of effectiveness means, and on the issue of state fault. I admit that I'm responsible for having introduced that clumsy concept into this case in the Inner House, but I do want to say that insofar as I'm saying that one of the parties to these proceedings is responsible, whether we call that state fault or not, it is only focused on the problems of proof which the taxpayer faces as a result of what we say was a repeated incompatibility with the right to deduct as a matter of EU law. Now, it may be that in the course of my submissions I will address some of the matters that have come up. But if I can first say something about the effectiveness principle. We say that the Inner House was correct in paragraph 18 of its opinion, which is at page 157 of the master volume, where it said that the basic test of effectiveness is whether the requirements of national law render enforcement of community right virtually impossible or excessively difficult. Excessively difficult, the second of these elements, is obviously more significant in practice. What that part of the test entails is a form of proportionality, which the National Court must assess the difficulty of enforcing the community right. In doing so, the Court must clearly have regard to both the evidence that is available and the reasons for any apparent deficiencies in that evidence. Now, I say that is correct, and that follows from the effectiveness principle, and it shapes the rest and ultimately the practical implications of the ruling which the Inner House makes. Now, as to the effectiveness principle, the Court of Justice has not been as clear as it might have been about what it exactly means when it speaks about the effectiveness principle. As my Lord Sales has said, the effectiveness principle is, in its origins, is a principle. I would say it is a general principle which bites on the interaction between substantive rights of EU law and procedural rights. I might call this the first element of the effectiveness principle, which goes back to the famous cases of Revy and Comet. But the Court has also used references to effectiveness in terms of the primacy of EU law. And we see that essentially relied on in Fleming, where they say that the cutting away of accrued rights of EU law requires the disapplication of national legislation which does so in order to ensure the full effectiveness of EU law. And I say in that sense, the Court, the House of Lords, this Court, and the European Court has used that in a wider sense of ensuring the primacy of EU law. And we see that, of course, famously in Siementhal in 1978, where a national procedural rule has to give way in order to ensure the full effectiveness of EU law. So this is another iteration of the principle. But as time has gone on, the court has also developed a third aspect, which is effective judicial protection. That might have, for present purposes, that began, I would say, in the Johnson and RUC case. It's not before your lordship, it's a famous case. Also, it so happens concerning evidence, of course, because it was the conclusory effect of a certificate, which was essentially the problem for the effective judicial protection which Ms. Johnson sought from the national courts in relation to her EU rights. Now, I say that all three aspects of the effectiveness principle are in play in this case. Certainly the Revy Comet angle is, but as we saw in Fleming, the interference with effective remedies is certainly in this sphere of that, is also an aspect of the primacy of EU law. That the full effectiveness of EU law requires effective judicial protection of what is ultimately an EU right. And the EU right, I do say, is the San Giorgio right. Why do I say that? It is now clear that, at least to me, that there is no directly effective right to recover overpaid or under-recovered input tax. And I say for all practical purposes, there is no difference. There is money the state is retaining, which you had a right to deduct. Now, my learned friend says, just because you have a right, you don't need to enforce it. Absolutely. The problem arises once you decide to enforce the right, and the state, for some reason, says no. Now, it might say no for a variety of reasons, in lots of cases. The Dutch case of Gemeldeheid, I think it was, which concerns about fraud, which is obviously material in the input tax recovery context. That had to be applied in light of the principle of proportionality. The problem, I say, is that the directive, while it says that the recovery of input tax must be in return, and of course that's the ideal scenario, inputs are deducted from outputs. And that is the directly effective right. The problem arises, and it's clearly what has bedeviled the law in this area for many member states, the problem arises for historic periods, when for some reason someone has not exercised their directly effective right to deduct. And the VAT is then trapped, as my learned friend put it yesterday. And European Union law can't tolerate that. It cannot tolerate the trapped VAT. The VAT is hidden, and it's disruptive to the market. The problem then arises when someone wants to exercise their right to recover the input tax which they could have done, but didn't.
Sorry, I'm so sorry. When you say EU law cannot tolerate the trapped VAT, I mean, clearly it can. If someone doesn't make a claim for the input tax, EU law has to put up with it.
Well, the neutrality of the VAT system proceeds on the basis that people will exercise their rights to deduct, and that it will be the final consumer who ultimately bears the burden of the tax.
But if you've got a right, you have the choice whether to exercise it or not. So if people don't exercise it, EU law has to put up with the, as you put it, the trapped VAT.
But it poses a problem for the system. It poses a problem for the system if the burden of the burden of the VAT is dispersed around the market. And is not recovered. The system proceeds on the basis that inputs will be recovered against outputs. People don't have to do so, I accept that. The problem arises when they exercise that right. When they exercise that right historically. Now, quite understandably, member states wish to put in place limitation periods, because the problem, of course, is that people will go back forever wanting to recover that. And it's quite reasonable, and the European Court has accepted, that limitation periods are permissible. Those limitation periods, however, must be predictable and they must comply with the principle of effectiveness. When the taxpayer seeks to recover the overpaid, under-recovered input tax, I say that they are essentially then relying on a restitutionary claim, all the more so if the state refuses to disgorge the amount that it has retained. So that ultimately, when push comes to shove, what we have is the San Giorgio remedy, one of the few remedies that the court has insisted that national law provide. And as the court said in San Giorgio, the San Giorgio remedy is integral to, it is an essential part of the, it's the counterpart of the right itself. It's one of the few remedies that national law must have. And I say that the invocation of the principle of proportionality in paragraph 18 of the Inner House's opinion is important in this context because we are entitled to ask for stricter scrutiny of the impediments which national law puts in place in the way of that remedy. And so when we consider whether the remedy is impossible in practice or excessively difficult, we have to pay particularly close attention to the obstacles national law puts in its way, in this case arising from this too strict an approach to the standard of proof, because of the importance, the key importance of that remedy as part of effective judicial protection.
But why is it too strict an approach to the standard of proof? Isn't the standard of proof on the balance of probabilities?
Which is a flexible standard, of course, and can be adapted to the circumstances of cases and take account of problems of proof that the taxpayer has and the reasons for them.
So do you accept that the standard of proof is balance of probabilities?
The standard of proof is the balance of probabilities, and that is, as the Inner House said, that is a flexible standard which can respond to the reasons for the taxpayer facing the difficulties that they do.
Well, that's the crucial question here, isn't it? Whether there's any reason other than the fact that the taxpayer has chosen not to make a claim sooner than for 30 years.
Well, can I address my lord on that? Chosen. The first point is that they weren't in charge of their tax affairs between...
Well, but they must surely... You can't claim that they're not stuck with the choices made by their predecessors in title.
Well, I do say they can escape those because they were created for the first time as a new public body in 1994. At no time previously were they...
But if they assume the rights, they must surely assume the obligations and everything that goes with it too. I mean, they can't say, well, just because we've acquired the rights, we're in a better position than the people we acquired them from.
Well, the complicating factor is, of course, I say the rights didn't fully exist in the first place, that even if they were in charge of their own tax affairs, there would have been difficulties. But I do say that they are entitled, as a new public body, as a new legal person, to pursue rights which wrongly, in breach of EU law, were not pursued previously by the predecessor.
You say wrongly, but there's no obligation to pursue rights.
There's no obligation, but when it comes to a later person considering whether an earlier person should have taken advantage of the law for budgetary purposes, they surely are entitled to say that we have a right to make a claim. That they now have the right, historic right, to make a claim that someone else did not previously make.
You say, because the predecessor chose not to make a claim, they should be given an extra assistance now they choose to do so.
Well, no, I don't pray any an extra assistance.
Well, a relaxation of the rules that would otherwise apply.
Well, not a relaxation. I say an application of the principle of effectiveness and a flexible application of the standard of proof, mindful that this is a historic claim, and mindful of the reasons for the problems of proof. That's all I'm saying.
What do you mean by a flexible application of the standard of proof?
Well, one that takes account, as the Inner House did, or said the tribunal should do, of the reasons why the taxpayer is in the difficulty they are of proving. That is, the reasons why they don't have invoices or primary records, which is built into the historical nature of the claim, and is also, I say, a result of the unlawful retrospective application of the limitation period in the later period of 1996 to 2008. The Court of Justice, has foreseen aspects of this problem. My learned friend took the court to paragraph 14 of the San Giorgio judgment yesterday, which is at page 2328 of the volume. But I would ask the court, as I also asked the Inner House, to look at paragraph 15 of the San Giorgio judgment on the same page. And this is quoted also in our written case, where the court says, in a market economy based on freedom of competition, the question of whether and if so to what extent a fiscal charge imposed on an importer has actually been passed on in subsequent transactions involves a degree of uncertainty for which the person obliged to pay the charge contrary to EU law cannot be systematically held responsible. Now, I say that what the court is saying there is that the effectiveness principle does not allow the risks inherent in uncertainty systematically to be visited on the taxpayer by virtue of the rules of the burden and standard of proof. Now, I also say, I would also refer, while we're here, to page 2299. Mr. Southern took you to the Advocate General Mancini's opinion in San Giorgio at page 2299, and I just wanted to highlight one slightly later passage in. So at the top of page 2299, the Advocate General says, to acknowledge entitlement to repayment, it's on the top right, to acknowledge entitlement to repayment as required by community law, and then to admit that in 99% of cases the right cannot be exercised. To say the least, a fine example of conflict between words and deeds. And I say that follows from visiting, also follows, as the court put it in paragraph 15, of systematically visiting the risks of uncertainty inherent in historic claims on the taxpayer. I don't want to say too much about Sanofi Pasteur.
Well, that was in a context, I see the very first couple of lines of that page of legislation, which he described as calling for proof of a diabolically high standard.
Yes. Well, I don't know what it was in the original Italian, my lord, but the too high a standard of proof, an undue suspicion of circumstantial evidence, a refusal to consider circumstantial evidence because of the absence of primary direct evidence, does lead to too high a standard, which is ultimately, I say, what Sanofi Pasteur says. I'm not saying that Sanofi Pasteur adds anything to San Giorgio in this respect, and I'm certainly not saying that it qualifies San Giorgio. I say it is to the same effect, and what it comes down to, especially at paragraphs 30 and 31 of the Sanofi Pasteur judgment, is that domestic rule...
Which page?
It's 2785, I hope, my lord.
Thank you.
What I say briefly is that domestic rules should not inhibit recourse to circumstantial evidence or necessarily impose too high a standard on considering it or be unduly suspicious of it. Because, as the court says in Sanofi Pasteur, too high a standard of proof of facts can make it excessively difficult to enforce EU rights. So I do say that the Inner House did rightly...
I think I'm right in saying that that's a case where the domestic rules of evidence, if you like, arbitrarily shut out logically probative material. That was the problem there. But
yes.
There's no such feature here, is there?
Well, not arbitrarily shut out, but if we go back to the tribunal judgment, and indeed if we look at the Commissioner's case, the Commissioner's written case before the Inner House, it does all come down, I say, to requiring effectively a standard of certainty to prove the amount of the historic claim. What they want is cross-checks to verify the witness evidence and the percentage calculated in 2006, 2007. The witness evidence before the tribunal, as Mr. Southern latterly pointed out, was accepted by the tribunal to the extent that the profile of business activities had not changed during the claim period. Now, if a historic claim requires primary evidence and cross-checks and verifications at regular intervals by reference to original data, then by its nature that is going to be impossible in 99, or virtually impossible in practice in 99% of cases. After all, the taxpayer only has to keep the records for 6 years. It's perfectly reasonable for, unless someone is a magpie or a hoarder, to say, well, no point keeping these records. The only person who will benefit from this rule of cross-checks and verification and verifying the percentage at regular intervals is the hoarder who wants to keep everything handy just in case it might help one day. Who can say? Now, into this...
It doesn't follow that because it mustn't be made too hard for you to make a claim, that it must be made easier after a certain amount of time goes by.
That depends on...
There's no reason why you should have a different approach to a 30-year-old claim than there is to a claim for 5 years
Well,
ago.
I say that brings us to state fault, my lord, and the passage from Advocate General Jacobs that I cite in the written case from Weber's Wine World.
From which case, sorry?
Weber's Wine World. It is, my lady, at 2622 of the master volume, and it is in paragraph...
That, as I recall, says, referring to a case where you've been prevented from claiming by the state.
Well, in effect, that is the position here, because after 1996, they rejected all claims that were more than 3 years old. They would not, after July 1996, the commissioners immediately refused.
Well, there was a period between 1996 and 2008 when you couldn't make your claim.
Well, that's 12 years.
You could have made it any time up to 1996.
Well, no, only between 1994, when the board was created, and 1996. There was a 2-year window.
All right, your predecessors could have claimed.
Well, they could have claimed, but of course the reasons why they didn't claim will feed into my Lord Law in the Chair's observations that the culture of the public service was not to do so.
Yeah, but you have to show, if you're going to invoke these remarks, that you're prevented from claiming, and that's a different thing.
Well, I mean, I would take my lords to it's not so straightforward. If we look at the Fine Art Developments case, which is a late authority that has been provided to the court, this does take us into state fault and the relevance of Advocate General Jacobs' observations, which I do rely on.
I'm so sorry. This is an additional authority. You say it's been provided.
Yes,
it
Fine
came
Art Developments.
It came through while we were sitting.
Okay.
I'm only going to take the court. I'm only going to take the court very briefly to it because it goes to what my learned friend was saying yesterday about the state fault here is only of a transient and minor nature. There were 12 years of our 47-year membership of the European Union, at least 12 years, when the United Kingdom was not complying with its EU law obligations because it did not have a transitional period. But I say that is serious state fault, and my learned friend, Mr. Southern, took you to paragraph 10 of Lord Hope's judgment. This was not inadvertent or accidental. And equally material would be 1677 of Fleming, Lord Neuberger, at paragraph 93. I'm sorry to jump around, but while we're here...
I'm sorry, I missed the page reference.
1677, paragraph 93 of Lord Neuberger in Fleming. It's just at the foot of the page, 1677. By contrast, Regulation 29(1)A came into force in May 1997. And the possible unlawfulness of not having a transitional period would have been clear to the commissioners well before December 1999. And yet they maintained it for some 9 years afterwards until the remedial legislation of Section 121 of the Finance Act 2008 was enacted. Now, The House of Lords considered, as Lord Walker says in his judgment, that the compliance presumption to interpret the national legislation to comply with EU law was not possible in Fleming. And the House of Lords set aside provisions of primary legislation because they were incompatible with the primacy, full effectiveness of EU law. That is not something that happens every day. That was a serious remedy which rarely happened. And that was because of the seriousness of the breach which the House of Lords concluded existed in Fleming. Now, I say that that is not a minor, transient, inconvenient irregularity to be swatted away like an inconvenient fly. It was a serious irregularity. And as Lord Neuberger is suggesting there, and it was, as was the case in practice, the Commissioner's position after July 1996 was to represent to taxpayers that they didn't have a claim which they could recover more than 3 years old. That was their public position for 12 years. And it was wrong, in breach of EU law. But my lords and my lady, it wasn't the first time that the Commissioners got it wrong. And we can see in the Fine Art case, which directly led to Section 24 of the Finance Act 1989, that provision, which for the first time gives a right in domestic law to seek repayment of overpaid or under-recovered VAT. Previously, there was a discretion, I accept that. There was a discretion from 1973 onwards which the Commissioners could exercise, but there was no right enshrined in domestic law until 1989. And what is interesting about fine arts is what the Commissioners were saying to the courts in this litigation. If I can direct my lords and my lady just to the head note, given the shortage of time, if I can ask you to look at the bottom of the summary of the facts. The Commissioners contended, and this is the Commissioners' case to their Lordship's House, the Commissioners contended that under the Value Added Tax Act 1983, the only sum that a taxable person could deduct from his output tax in a quarter was the amount of input tax he had paid in the same quarter, and that any regulations made by the Commissioners allowing credit for anything else were inconsistent with those provisions in ultra vires, and that in the circumstances the taxpayer company were not entitled to deduct or take credit for a previous overpayment. That was the Commissioner's public position, one that I venture they stuck with between 1973 and the House of Lords decision in 1989. And my lords, my lady, I say it was worse than that, because in other litigation, they maintained the position that if you didn't like what they decided, you could pursue them for an action had and received. Now, I have to say I've never quite followed that, because I don't know how that action would have prevailed in the years before Woolwich. Now, that was their public position between 1973 and 1989. And I cannot believe that the position that they adopted before the House of Lords was any different from the one that they adopted publicly to taxpayers. So I do say that the state's fault in this case goes back beyond the 12-year position between 1996 and 2008. I say that there are very long periods in which United Kingdom law was not compatible with the protection of accrued rights. In relation to Weber's Wine World, I do say that what I say is that what Sir Francis Bacon is ultimately saying there is that where the state has unlawfully introduced retrospective periods, it cannot then rely routinely on the rules of evidence to defeat claims lawfully which it previously strangled unlawfully. That is in breach of the principle of effectiveness, and certainly in breach of the principle of effective judicial protection and runs a coach and horses through the primacy of EU law and the full effectiveness of EU law, which is part of that. I had to take the court to fine art because I would also ask my lords and my lady to look at issue 3, agreed issue 3 in the Statement of Facts and Issues, where it is a matter of agreement between the parties that the issue before this court is the relevance of state fault in the sense of United Kingdom law not being compliant at material periods to the role of the tribunal in cases such as this. My learned friend I heard rowing back from that, but that is a matter of agreement before this court and prompts the reason why we felt it necessary to bring the court's attention again to fine art. I say that the Inner House was right to take account of the background and context of the convoluted history of the United Kingdom's relationship with the right to deduct. It was right to take account of the flexibility of the standard of proof. It was right to reject the need for cross-checks and the rejection of circumstantial evidence because there wasn't reliable primary data. As the commissioners had it in the Inner House, the inability to do cross-checks leads to the defeat of historic claims in 99% of cases. Only the magpie will win, and that simply is not compatible with the effectiveness principle. Finally, I cited Frankovich. Yes, I cited it not because this is a Frankovich claim, or only because it shows, like a long history of cases in the Court of Justice shows, that state fault is relevant to effective remedies. In the most recent case that we relied on in Boehringer, which I think we still only have a French translation of, it is, I think, the last authority. And I'm not going to...
No, it's 63B. It's not quite the last. Last is Zipvit.
It's 63B. I'm not going to try the court's patience by either trying to read the French or translate it. But without going into all the facts, the essential problem in this case was that in a transaction with the state, the taxpayer wasn't able to put in a figure for the accurate consideration on which output tax was to be payable. And it is paragraph 65 that I'm particularly interested in. Where the court is more or less saying that the principles of neutrality and proportionality, but I would equally say the principle of effectiveness, are particularly important where the difficulty caused for the taxpayer arises out of activities of the state and on the facts of that case in a transaction with the state. It is not possible to deny in the history of the court's jurisprudence whether it's Marshall with direct effect for directives visited on the state because the state failed to implement them, whether it's Frankovich, the state has failed to give full effect to rights and remedies. Where the state is to blame, that is material to the effectiveness principle. All the Inner House said was that that is also relevant to applying the standard of proof flexibly, all the more so in historic claims. My Lords, I won't detain the court further, and I'll ask my learned friend to conclude the case for the respondents.
Yes, Mr. Sutherland, is there anything to be added?
Well, I was said at the end when we started that why we say the Court of Session was to correct, to hold that the first-tier tribunal had erred in law. It would be fanciful to suggest, as my learned friend appears to have done, that the Inner House did not observe the distinction between appealable determinations of law and unappealable findings of fact. See Lord Drummond Young's classic formulation in the Murray Holdings case at paragraphs 42 to 48, which is on pages 1918 to 1920, and we would rely on categories, as the court did there, categories 2 and 4. The first-tier tribunal's determination was unsustainable, we would say, for 4 reasons. Balance of probabilities is a flexible standard. My Lord Leggett said, what does one mean by a flexible standard? The answers set out by Lord Denning in Beta and Beta at page 1940. It's a flexible standard which covers a spectrum. If fraud is alleged, a high degree of proof is required. If penalties are involved, a somewhat less stringent standard is involved. If tax avoidance has to be disproved, a higher standard is involved. But here this is a straightforward claim for VAT incurred historically. It's flexible enough to accommodate, so secondly, it's flexible enough to accommodate the effectiveness principle. All these point to the Inner House's observations at 64, which is on page 3024. The principle of effectiveness appears in our opinion to demand that, if at all possible, that claim should be quantified, and is also flexible enough to reflect the will of Parliament as manifested in Finance Act 2008, Section 121. And then fourthly, it can take into account the difficulties of proof in historic VAT claims, which are largely derived from the maladroit state of UK legislation for many years. The findings of fact of the first-tier tribunal are not disputed. First-tier tribunal made a series of important findings of fact in favour of the board, and up to paragraph 192, the current flows one way only, in favour of the board's appeal. But then at 193, which is on pages 3073 to 3074, there's a sharp change of direction, and the FTT concludes that the appeal should be dismissed by the reason of any absence of any primary documentation to determine the business income in the claim period, and a series of criticisms of the methodology which appear flimsy and beside the point. Finally, at 197, the tribunal lists the shortcomings of the evidence, but all deriving from the absence of primary documentation, which no longer existed and was impossible to obtain, and the resultant inability to make cross-checks. And the tribunal seems at the last minute to have lost its nerve and sought to hand the ticket back to God. This was a failure to discharge its statutory function. The conclusion which the tribunal reached was not supported by and was inconsistent with the undisputed evidence before the tribunal, and this takes us to the observation of Lord Tyre in the 2015 Lothian capital case. I'll find the reference to that in a moment, paragraph 19, that it's essential to have regard to the quality of the evidence. And we say that in this case, the evidence was of materially high quality, that in the language of Pasteur, the evidence put by the board to the tribunal was serious, specific, and consistent. And as the Inner House pointed out at 35, paragraph 35, in relying on backwards extrapolation from the year in which full records were available, the taxpayer adopted the obvious procedure in the circumstances. And in concluding that in all these circumstances, the decision of the first-tier tribunal should be set aside, the Court of Session did not invoke any new rule of law in saying that the court should adopt a reasonably generous and flexible approach. At paragraph 39, the Court of Session was not making any new observation. So we say the opinion of the Inner House affords the correct basis on which to resolve the case. In this way, the story which Lord Neuberger began in 2001 can be taken to a conclusion on a basis which accords with the will of Parliament, satisfies the effectiveness principle, and is fair, reasonable, and in the public interest. And if the board cannot win a case on these facts, no one can, and Section 2080 and Section 121 2008 will prove to have been writ in water. Thank you, my Lord.
Thank you, Mr. Sutton. Mr. Thompson?
I'm obliged, my Lord. I am generally content that the written and oral submissions for the Commissioners already adequately address the points that have been taken against me by the respondents. I think I can respond orally within about 3 minutes or 3 or 4 minutes beyond that. The first point I would make is a direct response to the submission that's just been made and was made on a few occasions by both Mr. Southern and Mr. Edward, to the effect that if this taxpayer can't succeed, no one can. That, of course, is pure assertion. And I think it would be fair to say it's not the experience of the Commissioners that all claims under Section 121 fail. The weight of the submission that was made by my learned friends, as I understand it, has as its anchor paragraph 28 of their written case at page 107. And this is the proposition that the failure to reclaim input VAT before 2006, and then quoting from the opinion of the First Division, resulted from a number of factors, including the failure of the United Kingdom to implement systematically the EU legislation on the recovery of input tax. So that's the context in which the whole discussion has been had about whether there was a proper implementation of EU law rights. And in relation to that, I adhere to the submission that the EU law right, currently reflected in Article 179, is to deduct inputs in the relevant tax period. That's what the EU law right is. And in the most pertinent domestic discussion of that, so the court has the reference, is to be found in University of Sussex, the judgment of Mr. Justice Neuberger, paragraphs 51 and 52, pages 1968 to 1969, in which his lordship expressly rejected a submission that EU law gave an enduring right to deduct inputs. I don't need to say anything about Fleming in light of the exchanges that took place between the court and Mr. Southern in relation to that. The final point I would seek to make is really just this. In the course of the submissions made by my learned friend, Mr. Edward, this morning, he referred to the proposition that EU law cannot countenance the idea of trapped VAT, and that fiscal neutrality effectively requires that that VAT be disgorged to the trader. My submission is that the other side of the fiscal neutrality coin is that persons should not be able to deduct inputs without establishing their right to do so in a definite amount. And it's the deduction of inputs without the establishment of the right that would give rise to a breach of fiscal neutrality. The last point was in relation to the statement of facts and issues and agreed issue 3. I think there was some suggestion that the commissioners are rowing back from what's said there. For the avoidance of doubt, the reason issue 3 state fault is identified as an issue to be decided is because that's precisely the basis on which the Inner House decided the case. It's certainly no acceptance by the commissioners that there has been state fault properly understood. Lords, for those reasons and those which I advanced yesterday in writing, I invite the court to allow the appeal.
Thank you very much, Mr. Thompson. We're grateful to counsel for their submissions. We'll now take time to consider them and let you have our judgment as quickly as we can.